crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Good evening and welcome to the attorneys. Thank you so much for joining us on this Sunday evening. I have a really interesting conversation headed your way and a panel of experts. We think you're going to enjoy this. We appreciate you being with us, and a couple of ground rules of kind of how this works in case this is your first time with us. All throughout the program, you'll see ways you can join our conversation. That's going to be at the bottom of the screen, but a couple of numbers that you're going to want to make note of. So write these down in case you have questions you'd like to get to the firm of Hollis, Wright. To text, the number is 205-670-1949, or you can call 844-529-8255 or 844-LAW-TALK. Also, Hollis Wright makes available all throughout the program tonight attorneys that are standing by right now. That free, confidential, and off-air conversation is yours, so take advantage of that if a question pops into your mind and you need some free legal advice. Leading our conversation, he's the managing partner of Hollis Wright. Josh Wright, good to see you,
How
sir.
are you?
I'm good.
Good.
Good
week?
Good? Yes.
Doing
How about
great.
you?
Oh, well, doing great. You know, it's just busy kind of holiday season, but everything's been
that
great.
time of year,
It
isn't
is.
it? Yeah.
Weather started cooling down a little bit.
A little
It's starting
bit.
to feel a little bit more like Christmas.
It needs to.
You got all your, you got everything purchased?
Not even, well, the first one.
Well, let me tell you somebody that does. This guy right here,
Allwin's got it
Allwin Horn.
together?
He's always well in advance.
He comes prepared, I know that.
So, you know, let's kind of get into what our show's about tonight. We're going to be talking about work-related injuries. And we do a lot of shows about work-related injuries, but there's a reason why, and that is because in the area that we are in central Alabama, there are a tremendous number of workers' compensation cases. Right. Think of all the construction and all the business that we have in this area. And so one of the things that our firm decided to do several years ago was to join forces with Allwin Horn. And Allwin has had a thriving workers' comp practice, does some other things too, but had a thriving practice for many, many years. And rather than trying to beat them at workers' comp, we were like, hey, let's just go join Allwin. So we got Allwin to come over to our firm, and it's been a great union between the two groups. We work together now, and it allows us to be able to service all the workers' compensation litigation that we get in-house with Allwin, and it allows him also to have the flexibility to be able to work with us.
I know you're about to say hello to Allwin, but how long have you two known each other?
Well, he was my wide receiver back in flag football in law school.
Really?
Till he dropped that one pass.
Just one. I made up for it.
No, we've known each other. We've known each other since law school.
Since law school.
It's been
awesome.
over 20 years, and we live close to each other. And he's a great friend. So first of all, welcome aboard. Glad to have you here,
Dave and Josh. I appreciate y'all having me here.
You know, one of the reasons we wanted to do a work-related show is to be able to talk about some of the tricks of the trade if you've been in a work-related accident. One of which is people may not realize this. If you do not notify your employer within 90 days, that's not a long time. No, a lot of injuries nag over a period and you're not sure if they're work-related or not. If you don't notify your employer within 90 days, you can be precluded from bringing suit under the workers' compensation statute. So having Allwin aboard is going to be helpful today to be able to go through some of those rules of the road, if you will, for comp stuff. All right, first of all, tell us just a little bit about kind of generally, what is a work-related injury? Because I hear so much people call and say, well, you know, I was injured on the way into work or I was injured on my way home. And, you know, I like to be able to make sure we address that issue.
You know, the general rule is, or at least how it's defined under the Act is, you know, the event or injury had to have occurred during the line, scope, and course of your employment. And, you know, in general terms, that would mean if you were doing something in furtherance of your employment, you know, if you're, whether, let's say, even if it's during a lunch break, but you're required to have lunch on the job site, then that is considered in the line, scope, and course of your employment. If you're driving, you know, driving to make a delivery, if you're walking up the stairs carrying a load, anything that you are doing in furtherance of your employment is considered in the line, scope, of course, of your employment. So if there's an event, a single event that happens during that time frame, you are covered. And of course, you have other circumstances such as cumulative stress injuries, which may be people that do repetitive work and have for years, you know, working on an assembly line or something, and over time those occurrences add up to create an event or an injury that is compensable as well. You can also have occupational exposures. people that are exposed to asbestos or coal dust or any other chemicals that over time accumulate and result in an injury or condition that's covered.
What's your recommendation for someone that thinks they may have a work-related injury, but they're not 100% sure? I know there's kind of a political side to this too, because sometimes people do not want to notify their employer, their fear of retaliation. What's your recommendation? Is it to, hey, at least come talk to somebody? I mean, how do you handle that?
Absolutely. I mean, I would say definitely speak to somebody, because employers have human resources departments. They have people that are trained in the Workers' Compensation Act. They also have insurance companies and insurance adjusters they deal with. They know what to look for, and oftentimes, I mean, this isn't with every employer or insurance company. They're wanting to deny claims or to avoid claims because it costs them money. Yeah. So my suggestion is that employee go to a lawyer. Lawyers that work like us, I mean, we don't charge them to talk. We give free advice. We consult them. We advise them. We're familiar with the law, just like a human resources department might be or an insurance company might be, and we can tell them whether they have a claim. Now to go a little step further, something you pointed out at the beginning of the show is that there is a 90-day threshold to report an injury, but typically you want to do it within 5 days. The 90 days is the exception. If you think something's going on, report it. I know you may be concerned, but if you don't do it, then you may waive your right to benefits, and who knows, it could turn into a lifelong problem that you need medical treatment for.
Allwin has told me for years related to this area that a lot of times the retaliation, where someone retaliates against someone that filed a workers' comp claim, the value of that claim may even be greater than the workers' compensation claim. So people need to recognize that the legislature has put together some teeth in the statute, David, that do protect people, that do not allow an employer to retaliate against you. And if you can prove retaliation, a termination, a demotion, other things, a lot of times the value of that claim is even more significant than the underlying workers' comp claim was. So people ought to be able to use the workers' comp system and insurance that employers have.
We got a couple of minutes before we have to go to break. I want to get in a question because we love getting these questions. I hurt my leg while doing my job. I gave the doctor's bill to my boss, who told me that I have to pay it because he doesn't carry workers' comp insurance. I thought all employers had to carry workers' comp. Is that not the case?
That is not the case. The rule is that you need to have 5 employees in order to be required to have workers' compensation coverage. Now, there are plenty of employees that have less than 5 employees, and they also have coverage. So it's an election of the employer, but if there are more than 5 employees by any single employer, they are required to have coverage. If they don't have coverage and you're injured on the job, they can be subject to double a double penalty. In other words, you could, as the injured employee, you can double your compensation in making a claim if they have failed to provide the coverage.
How often do you see that?
You don't see it a whole bunch. Okay. You really don't see it a whole bunch. But I have seen it before, and I've actually pursued it, and I've actually gone to court, and I've actually had a judge award a double recovery for their failure to have coverage.
I know we're getting ready to get a break. When we come back, I want to talk a little bit about how Allwin kind of got into this area of the law, and how the law has changed and evolved since the time that he and I started practicing law together, because there have been some significant changes. And then there are some things that won't change and haven't changed and need to change. So we'll talk a little bit about those things.
All right. We're stepping aside. As we do so, just a quick reminder, would love to have you follow Hollis Wright on social media all over, Facebook, Twitter, Instagram. Just search Hollis Wright and you'll find him there. A great resource to kind of keep up with what's going on at the firm, but also very educational and informational as well. Stay tuned. We've got more of The Attorneys coming right up. Stay with us.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
That we would be able to use the resources of the many lawyers we have at this law firm to create a plan that had a lasting impact that also gave back to the community at the same time. And I think we've done just that with the attorneys.
Welcome back to the attorneys. Thank you for being with us. Before we jump back into our conversation, I want to remind you at the bottom of your screen ways you can join our conversation, and attorneys from Hollis, Wright standing by live all throughout the program to take your call. That free, confidential, and off-air conversation is yours for the taking, so pick up the phone and give them a call. Josh Wright, Allwin Horn here with us tonight. You may know them better, the 30 for 30 ESPN show, the Immaculate Deception. Yeah. And the touchdown that wasn't, I think, is what it was. We'll get that. We'll clear that up later.
That's right. We're caught many passes. Caught many passes. And
it's one that he didn't. That still stings.
I still like
we
to.
We still won, if I remember.
I do think we still won, and I lost my position the next week to a better quarterback, so it was all good. All right, hey. So I know we've been friends forever and practiced together for a long period of time. But how did you get into this area of the law? Because you hear about workers' comp attorneys. There are not, and I know you do stuff other than comp too, but there are just not a lot of workers' comp lawyers that really focus on it like you do, and that's why you're kind of the go-to in Birmingham.
Well, when I appreciate that. When I started close to 20 years ago, I was with a firm that had engaged in that area of the law, and it was relatively new then. I mean, of course, I guess the act had been created about 10 years before, but there weren't a whole bunch of lawyers that were doing it. And I think a lot of lawyers may have stayed away from it because, in this area, us as the lawyers, our fees are capped. You can't make a bunch of money off one individual case because the percentage you're entitled to take as a fee is lower. And but once you learn it, it creates the ability to meet a lot of people. I represent a lot of people that didn't do it, and it just opened up the doors for something someone else didn't do. So I got a lot of business doing it.
Talk a little bit. I know your dad's recently passed, but talk a little bit about your dad's role in the bar was significant. I know that really helped you too.
Well, my dad was an attorney and ended up being a judge, and he retired, and of course was working with us for about 10 years. But he might have pushed me a little bit that way, and I guess coming out of high school or even college, who knows exactly what they want to do. So I took a leap of faith and went to law school, and everything's worked out. At least I'm still sitting here practicing.
Well, and Judge Horn was worked with our practice, and a good man and a great judge in this area, and is in a better place now. But all right, let's talk a little bit about this. Over the last 20 years, some things have changed, and there are some things about the comp statute that have not changed at all. Let's first talk about some of the things that need to change in the comp statute that I know you've been working on in the state, and the legislature has been kind of pushed in this area.
And there are other lawyers that need recognition in Alabama, throughout the state, and especially in Birmingham, that do as much or more than me towards that area. But for the last several years, something that needs to change is the amount of compensation awarded, especially in the form of temporary total disability benefits when someone's injured. When someone's injured on the job and they're out of work recovering from their injury, say they've had surgery or for any other reason the doctor takes them out of work, they're entitled to 2/3 of their average weekly wage. But then when they are permanently healed, so to speak, they're placed at maximum medical improvement, the amount of compensation they're entitled for a permanent partial disability is capped at $220 a week. And that amount was set in 1987, and it hadn't changed since. And that number, it comes up so often because there's a mathematical formula to determine the value of a workers' compensation case, depending on impairment ratings and such. And we pushed forward to try to almost double that cap, but we haven't been able to get it through the legislature. But you think about what a Coca-Cola out of a vending machine cost in 1987 and what it costs today, or what the power bill might have been at that time, or water bill, and it just doesn't reflect the compensation someone should be entitled to, which is based on their wages.
You know, when I was trial lawyer president, that was one of the things that we really lobbied for to try and get changed to, and Allwin was involved in that effort at the legislature. And you know, I'm not blaming the legislature. The reality is there are lobbies that are against changing that metric, that number, that are powerful in the state. And so for one reason or another, there's not been an adjustment. The hope is that in the future that'll change.
Right. Another question we've got here, it says, I work in a factory that is very loud. I've noticed that I cannot hear as well as I did just last year. Others who work with me tell the same thing has happened to them. Is this a case?
It's based on those facts alone, what you gave me, it sounds most certainly like it is a case. You know, in the Alabama Workers' Compensation Act, you have what's called scheduled injuries and then bodies to the whole person. Loss of hearing, one good thing about a loss of hearing injury, other than someone has the injury, is the fact that it's not just a scheduled injury. When someone loses their hearing on the job, it affects the whole person. It affects what they can do with their entire body and what jobs they can engage in. And the reason I point out the difference in hearing loss and versus, say, an injury to an arm or a hand, which is a scheduled injury, is that it's a permanent condition that can last the rest of your life.
Right.
And I guess that's what I need to say about that.
Yeah, no, that makes sense. Talk a little bit about what doctors you have the ability to go see, because I get this question a lot at the firm. Hey, I was injured on the job and I went and saw my personal doctor. What do I do now? Talk about that.
Here's one unfortunate thing with the Alabama Workers' Compensation Act is the insurance company and or the employer typically they have the right to control the medical treatment. They get to select the doctors with few exceptions and send you to their treating physician, so to speak. And of course, as long as that individual becomes the authorized treating physician. But if that doctor refers you to another doctor, that doctor then becomes, you know, the authorized treating physician. But you know, if a physician connects the injury, let's say the hearing condition, as being caused by repetitive, you know, exposure to this noise in the plant, then it's deemed compensable. And the insurance company sometimes will try to pull, you know, an injured employee away from a doctor they've selected because they don't like what's being said. They don't like the money they're going to have to spend on the claim, but they can't do that.
I want to talk about two things before we go to break, and then the next segment, I got a really good topic we need to address too. But first thing, let's talk just for a second about if you do not like the doctor that you're going to, do you have the ability to work with your lawyer to get a panel of other doctors to consider?
You do. You have the right to obtain what's called a panel of 4 physicians. And if you're unhappy with the doctor you're seeing in the given specialty, for example, you know, you're seeing an orthopedic for a knee injury or a leg injury, if you're unhappy with that doctor's treatment and you need more treatment, you can ask for what's called a panel of 4, and the insurance company has to give you a list of 4 orthopedic doctors in the area. It should be within the area. A lot of times I might try to send you 2 and 3 hours away, but you can fight that as well.
And I know we're getting ready to go to break, but just real quickly talk with me about what are the general types of damages, just kind of the broad topics that you can get in a comp case.
And you have 3 or 4 different types of benefits. We refer to them as benefits. You have your temporary total disability benefits. That's when you're out of work recovering. Once you recover and you're placed at maximum medical improvement, you're entitled to what are called permanent partial disability benefits. That would be an impairment rating less than 100% or a vocational loss less than 100%, meaning you can't return to your pre-injury job status, but maybe you can do some form of lighter work. That's permanent partial disability benefits. You have permanent total disability benefits, which would be awarded for life for a permanent total disability or 100% vocational loss, and you're entitled to medical benefits for an on-the-job injury that the insurance company is responsible for life.
All right, so that's a great example of why you want to have a lawyer on your side. What he just whipped through is complicated, right? And he knows that, and we all know that. And the employee should know that. And that's why you want to go to a lawyer like Allwin to make sure that they can lead, guide, and direct you through the process to make sure you get what you're supposed to. I know we're getting ready to go to break. When we come back, I want to talk about third-party litigation, which are claims outside of your employment with a third party, and co-employee litigation, if a co-employee caused your injury and how that plays into workers' comp.
Sounds good. All right, we are stepping aside. This is our final break of the evening. Whenever we come back, we're going to jump into those topics of conversation and wrap things up here. A few minutes remaining.
I'm Drew McNutt with the law firm of Hollis, Wright. We often get asked what happens if someone is injured by a motorist who doesn't have any insurance coverage. In tonight's Legal 411, we will address uninsured motorist coverage. Under Alabama law, all automobile policies issued must provide uninsured motorist coverage unless the name insured rejects the coverage in writing. If you purchase this coverage and you are injured by an uninsured driver, you can make a claim against your own insurance company to compensate you for the injuries caused by an uninsured or underinsured driver. While liability insurance is required by state law, it is estimated that over 20% of the motorists in Alabama do not have any coverage at all. Uninsured motorist coverage provides you with the ability to protect yourself and your family in the event you are injured or killed by one of these uninsured drivers. If you are concerned about whether you're covered, I recommend that you check your declarations page or contact your insurance agent to discuss your coverage options. If you do not have uninsured motorist coverage, consider adding it. And if you do have it, discuss increasing your limits. Oftentimes, you can purchase hundreds of thousands in coverage for less than $100 a year. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on the real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys on WVTM 13.
Welcome back into The Attorneys. Just a few minutes remaining. You want to join the conversation, that info at the bottom of your screen, or you can call us 844-LAW-TALK or text us at 205-670-1949. Josh?
All right, so when we went to break, I wanted to talk about, in this segment, a little bit about how what's called the exclusivity provision works. Let's first address that, and then I want to talk about third-party and co-employee litigation, because I know you and I work a lot on that together.
And that all runs together, and it's a great point. Under the way the Alabama Workers' Compensation Act is written is that an employee, generally speaking, cannot sue their employer for anything but workers' compensation benefits. It's referred to as the exclusivity provision. The employee can only sue their employer exclusively for workers' comp benefits, but there are exceptions to that. And the ways around that would be, you can oftentimes, as an employee, if a co-employee has done something wrong, of course the burden of proof is high. You can file a claim against them, and oftentimes they're covered by their insurance policies. But most importantly, a lot of times, especially in, say, construction accident claims, you have multiple parties there. You have contractors and multiple subcontractors there. And an employee may be injured by an employee of a different employer. And then you have another claim there which is based in negligence or whatever it may be. And the importance of that is that, while the Workers' Compensation Act gives you guaranteed benefits as an injured employee, a lot of times, and really most of the time, if it's a serious injury, those benefits or the awards or compensation are a lot lower than what you could recover from a third party. Right. And that's another reason why it's so important to go talk to a lawyer. It's confidential. We're knowledgeable. We know what we're talking about. We may see something you don't see, and of course, your employer or their insurance company is certainly not going to tell you, "Hey, go this route so you can get more money and more compensation."
Yeah, I mean, think about a good example. And I mean, a recent example. Electrical contractor working on a bridge abutment in downtown Birmingham. There's a general contractor that's responsible for providing fall protection for him, does not provide the appropriate fall protection, and he's injured. Mm-hmm. And so in that claim, he has a workers' compensation claim against the electrical contractor, all right? And that's going to be a limited recovery. We've talked a little bit about that today under the Workers' Comp Act. And then he has a third-party claim against the general contractor for failure to provide appropriate fall protection, failure to provide netting, failure to provide lanyards, whatever it may be. That's a great example. And so it allows you to get outside of the Workers' Comp statute and pursue an actual negligence claim for failure to provide something, which is a probably more valuable claim in that scenario.
And let me add this too. Also, another reason it's important to speak to a lawyer is these claims it can be considered a double recovery. Something most people don't know. Let's say that you have your workers' compensation claim, and then you were to handle a third-party claim while I'm handling the workers' comp claim. If there's a recovery on your end, against the third party's carrier, or you are responsible for paying back the workers' compensation insurance company for what they've paid. And an employee can get themselves in trouble if they don't know that.
Yeah, that's a great point. We talk about subrogation a lot on the show. We've done a show on subrogation. Mm-hmm. Medical subrogation, same concept with workers' comp.
Real quick, this question, what can I do about earning money for my family if I can't go back to my old job because of my injury?
That's a good question, and the key is not being able to go back to your old job. This is, when we sped through all the benefits you're entitled to in the Alabama Workers' Compensation Act, I think one of the most important benefits is what's referred to as vocational benefits, or the rights to vocational retraining. A lot of times people have injuries. Let's just say you've been a long-haul driver most of your life, driving an 18-wheeler, loading trucks, getting up and down off flatbeds or in and out of the cargo trailer, and you have two spine surgeries as a result of the on-the-job injury, and your physical limitations prevent you from going and doing that type of heavy labor. So your restrictions may place you in what's referred to as like a lighter duty job, or a job that is less physically demanding, and you then have a vocational loss. And a lot of times your vocational loss, which can be, let's say you've lost access to 60% of the job market based on your restrictions, which when beforehand you had access to 100% of the job market, those benefits oftentimes are higher, and noticeably higher than what you would get, just say, for an impairment rating in terms of the permanent compensation you can get.
We have less than 2 minutes remaining, just time enough for a final thought from the both of you. And Allwin, if you would, you go first.
I would just say that if you're injured on the job, I would act immediately. Just contact an attorney, speak to them. I hope we've indicated that we know what we're talking about here, but lawyers that specialize in this area might give you some ideas or thoughts or ways to handle your claim that aren't presented to you. There may be a concern of retaliation, but it's confidential. And a lot of times we can assess whether it's going to be worth your time and effort to go forward with litigation.
Yeah, and I think we've done a good job of explaining it today. Allwin specifically talking about how complicated the benefits you can get, just talked about vocational retraining. You need to get to an attorney to help lead, guide, and direct you through the process to make sure that you're maximizing your recovery. You also want an attorney to evaluate whether or not there are third parties potentially responsible for an injury, and to evaluate whether or not there may be co-employees that would be responsible for the ultimate injury that you sustained, because it could open up other, if you will, opportunities for you to recover. And the last thing I would say related to all that is this. You want to go to a lawyer that really understands the law. Allwin is great in this area. There's a reason he is known as the go-to workers' compensation lawyer in the area, and it's because he's been doing it for so long. So I'd highly recommend you contact Allwin if you've got questions, and he can walk you through it. It's confidential, so you've got an opportunity to make sure you're protected.
That sounds good. Allwin, thanks for being with us.
Dave and Josh, thank you for having me.
Good to see you as well. Thank you for being with us.
Thanks for watching The Attorneys, sponsored by Hollis Wright.